Hello, everybody, and welcome to our monthly webinar. We're thrilled to have you on board. If you are listening live, please send us your questions. You can use the comment field right in YouTube, and you can send us live questions, and we'll take them at the end of the episode. So you've got your questions. I have a feeling if you don't have questions, maybe you might not be wired right. This is ripe for questions. I'm very, very excited about this conversation. And now let us begin. This month on Human Solutions, we're diving into some of the most personal and uncomfortable situations HR professionals and new managers face. Conversations most people would rather avoid. From addressing body odor with an otherwise high performing employee to responding when someone discloses domestic violence to knowing what to do when you suspect an employee is under the influence at work. These aren't just policy issues, they're people issues. We'll explore not just the human side of these challenges, but also the legal implications. I'm Pete Wright, and joining me today are our heroes of the helpline, Terry Cook and Tom Jones. Hi, folks.
Hey,
Hi, Pete.
Pete.
Good to see you again.
I think we should just dive in because I feel like I've been holding myself back in our pre-show, not digging right into this conversation. It seems like this is possibly the most awkward conversation you could embark on. How do I bring up body odor with an employee who otherwise does great work without making it awkward? Let's start with Terry before we get into the law, can we?
Of course.
Sure.
So I think when people think of body odor, they think of obviously the negative type of body odor, which is definitely the harder thing to bring up with an employee. But before we dive into that, just bringing up a few other things that could come up with body odor. Some people are wearing excessive perfumes or colognes that are affecting employees' allergies. Some people have a strong scent of cigarette smoke. It could be any type of body odor. But I think, Pete, what you're probably bringing up is probably the one that's most uncomfortable to bring up when somebody is being reported by other employees of having a smell that you need to address. So there are several reasons why we have to address it, and I'll leave those legal reasons to Tom in just a minute. But as far as having the conversation, it's important to be sensitive, know that it will be a difficult discussion to have, but bringing that person aside, sitting them down, having a talk with them just to say that this has been brought to our attention. It's a tough topic, but I'd rather talk to you about it directly than for you to hear it from other employees. So we just need to talk about what's been brought to our attention and then go from there to have these discussions, let them know what's come up, listen, find out if there's reasons behind it. There sometimes are, whether they're reasons that might be financially related or reasons that might be medically related. Mm-hmm. So I would say really being sensitive, empathetic, listening are important to starting the discussion.
At what point, you're also, I assume, bringing up cultural reasons, right? If you work in a cross-geographic team with different expectations, sort of sociocultural expectations of body odor gets in the way too. So, all right, Tom, why is it legally touchy ground?
Well, I mean, a couple of things come to mind immediately. One of them is the employee who's come to you and complained about this may have some form of what they call multiple chemical sensitivity disorder, which could be an allergic reaction, could be some sort of very sensitive reaction to a scent or an odor, cologne, body odor, whatever it might be. But that could be one thing that triggered it. And if those two people happen to sit next to each other in the workplace, that could trigger that problem. The next segue over would be the Americans with Disabilities Act, which, back to Terry's point about people saying there's a reason why this issue sits out there, is that the person may have difficulty with, an illness, something in their body and their background that causes that odor to emanate from them. Then the question becomes much more of a legal one. What can the company do? What must it try and do? What can it do? What presents an undue hardship and just is too much to do?
I would love to hear from you, Tom, some of those examples. Have you run into this specifically from a legal context?
A couple of times we've come up in Helpline. Terry, feel free to jump in too, but it usually goes with the Americans with Disabilities Act rather than the chemical sensitivity disorder. People report that they have some disability or some condition that they believe is a disability that may have caused that odor to emanate from them. So every so often it comes up on the helpline as to what may be going on with that person or not. It's, I don't know, Terry, do you have anything you recall?
Sure. I think another example that comes up is if there is not a medical condition, as Tom's indicating, um, what can come up, and Tom can expand on this, is it can create a hostile work environment.
Hmm.
It's something that people don't think of immediately when it comes to body odor in the workplace. But that is something that could come from this if there's enough concern. And Tom, I don't know if you want to touch on that briefly.
Sure, the discrimination laws in most states in the country would offer some possible relief here. And certainly it's something, if you were concerned and motivated, you'd want to explore it. I mean, employees may consider exploring that as an option. Would be to pursue and say, I feel like this is maybe uncomfortable in the workplace. The company fails to do anything about it. Therefore, I think it's created this hostile work environment. You know, whether that fully is recognized under the law, might be just, excuse me, pushing the bounds as to what constitutes a legal theory for relief, but you never know. You never know where the courts may go.
Is the privacy situation kind of a fine line, or is it obvious? I'm legitimately wondering if the fact that, you know, other peers are reporting a body odor issue becomes an issue of privacy for that employee.
Well, and at least the law in Massachusetts, you think of privacy would be putting your two hands in front of you and weighing out who has the right to know, who has the right to do something.
Mhm.
Is it the employee's privacy versus the employer's right to address this? So 4 or 5 employees come forward to HR and say, this is a problem. The company acknowledges it's a problem, is aware of the problem. Then I think the privacy side goes away and the argument is the company has to do something about it. And I think you'll see privacy show up in the other two issues we're going to talk about today as well. But at some point, unless the person's working remotely isolated in some situation, then we could try and protect their privacy a bit more. If they're
Mhm.
interacting with fellow coworkers, customers, clients, then I think the company is effectively duty bound to try and resolve the issue as quickly as possible. And the privacy won't be a concern.
Terry, can you wrap us up and help us think through some of the things that a company can do? If companies duty bound to take action, what does the end of this awkward conversation sound like? Because my assumption is we want to make the office environment feel safe and welcoming while going through, you know, this sort of company awareness of my body odor.
Sure. And as you're mentioning, you know, body odor that might not be excessive perfumes and things of that
Mhm.
nature, you know, we would have the conversation, explain, as Tom mentioned, multiple employees have come forward. We just need to talk about this, talk about a solution. As I mentioned earlier, sometimes it's a financial situation. You know, there's
Mhm.
been scenarios where, you know, as a company, we've purchased products for an employee because they just admitted they could not financially afford it. So that was one solution. When it came to somebody that was using excessive perfumes or sprays of those natures, we were able to talk to that person about, you know, something significant like allergies. You're impacting somebody's health right now. You're not meaning to, but there's reasons why we have to do that. And we would put a posting up, actually, what I've done in the past, indicating that due to allergies, we have to we can't have any type of excess scents in the workplace.
Right.
So we're able to attack it from that angle. But again, it's really having that discussion, listening, being sympathetic and empathetic to people, because, you know, once people hear about this, they either react one of two ways. In my experience, they're very defensive,
Mhm.
and they get upset and they deny, and there's no way that they want to see it. And the other is embarrassment. You know, if somebody hears this, they weren't aware that this was happening. They don't want to hear it, and they don't want to hear it outside of the office. So again, I've actually had people say, "Thank you for bringing it to my attention. I didn't know. I didn't know everybody was talking about me."
Mhm.
And this particular scenario was the financial issue. So we were able to resolve that for him. And then in another situation, it was more of what Tom's mentioning. It was actually a medical condition. And it was something we were able to, you know, through discussion and exploration with their physicians, we were able to find solutions there too. So it is an awkward conversation. It's not one to just avoid, which a lot of people would like to, because it's not anybody's favorite thing to do is to sit somebody down and say things like this. But it's one that in HR, we have a responsibility, and we have a responsibility because we need to be people talking to people, but
Mhm.
also from Tom's standpoint, from the legal perspective.
Terry, you brought up the reaction of somebody who responds with sort of belligerence, right? I don't want to
Mhm.
hear it.
Mhm.
This is not my thing. We've been talking about the more sort of delicate, congenial kinds of awkward
Mhm.
conversations. What opportunity do you have to affect change with somebody who is ideologically disposed to not?
Mhm. A lot of times it's actually being open with them about the potential for a hostile work environment claim
Mhm.
to come to to the company, to them.
Mhm.
So we have to address it as a company. It's not something that we can pretend is not happening or what have you, because, and I always would assure them it's not one person complaining, because the person that's defensive will say, "Oh, I bet I know who said that about me," because they don't like me.
Mhm.
And I always assure them and say that's the company wouldn't necessarily respond this deeply into this if we didn't have reason to believe it was accurate. So
Right.
whether it's our observations personally as manager or HR, or it's multiple employee complaints coming forward.
One of the other
Um,
things, Pete, that I think makes a difference is creating a policy up front. Try and put a policy in your handbook to address dress code and appropriate dress in the
Mhm.
workplace, and put something simple in there like you must have deodorant. You must use deodorant appropriately in the workplace, or to Terry's point about cologne, perfume, whatever it might be. And that helps HR because you can then point back to the policy and say, here, we've had this policy in here a couple of years, just letting you know, reminding you, sometimes the reminder, sometimes that may diffuse the angry employee. Yeah,
yeah.
it's right. At some point, the employee might just say, "I don't care. I'm so offended. What's happened to me," and you might end up
Yeah.
with this claim somewhere, or someone might quit. All those things could happen.
Let's turn our attention to a conversation that is maybe as awkward, certainly more difficult. That is this. What should I do if I suspect an employee is experiencing domestic violence? And what if someone discloses they need help? How do we create an environment of trust in that conversation? Terry, you want to kick us off?
Sure. And I think what you just pointed out is the trust piece and being sensitive, as we've already mentioned in the last scenario. So when you see something that you're worried about or questioning, don't make an accusation about, you must be experiencing X, Y, or Z. It's really about sitting down, talking to the employee and saying, we've seen some differences here. We're trying to see if there's anything we can do to help you. Is there anything going on that we need to be aware of? We have leaves of absences available. We have an employee assistance program available, depending on what comes up in the conversation. So again, it's listening. It's making sure that you're establishing a safe environment for them to share. So I think those things are really key to getting the conversation started. And if somebody does disclose that they're in a situation of domestic violence, introducing what you can do, but also first and foremost, finding out, are they feeling like they're in danger, even at the workplace? Because we as a company
Mhm.
want to make sure that they're safe at work. And sometimes that has happened and some restraining orders have come into play, or we've made sure that, people at the doors are well aware of a person that's not allowed to come on site. So there's a lot to go into here if somebody is willing to share that, and if it's something they are going through. And then, again, there's different leaves of absences available, one specifically even for domestic violence that I think Tom will
Mm.
touch on as well.
Let's do that. Tom, what
Yeah.
are your obligations?
Well,
Of
depending
this
on the
situation?
state, I was looking through this morning. Depending on the state, excuse me, you may have different leave laws that may go anywhere from 3 to 5 to 15 days. Job protected time off from work to go to court, go meet with your lawyer, take your kid out of school, move to a different house, whatever it might be, whatever you have to do. So many states have got some sort of legal protection in place, knowing that this, and it's true that over the last 20 or 30 years, it's become much more aware that this is a real, genuine issue than it used to be. And so you saw much more protection being offered to folks. Many states, in fact, allow people to collect unemployment if they can show that they had to quit their job, even though it was a voluntary quit in the legal sense, it was
Mhm.
involuntary in the social sense, that they were forced out by coworker who was threatening them, by a former partner who was hanging around the workplace, and they had to leave and go to a different part of the state to live in. So there are more and more protections coming down. And what I've noticed, though, and it's not all that widely known about, like Massachusetts has a law that says if you have 50 or more employees, you have to have a policy. Some other
Wow.
states it's 15, 12. I think Oregon, I was looking, it was 12 to 50. It was a range where it kicked in depending on the amount of employees, the amount of time you got off. So more and more states are doing it, but it is definitely not one of these things that's publicized anywhere near as much as, say, sexual harassment or anything like that. And in a way, that's fortunate. You don't want as many people being victimized in the workplace. Excuse me, being victimized in the workplace as you do is recognize sexual harassment much more frequently. But it's definitely an issue that's out there. You see more and more of a problem
Yeah.
with it.
This is one of those topics that we've, I over the last 50 years, our organizations have really had to get more and more involved in these sorts of issues to protect our employees, because these issues bleed into work. Do you have any comment on our current political situation? Are these kinds of protections at risk at all?
At the state level, there shouldn't be.
Mm-mm.
I mean, at the state level, I would think not. National things that are like unemployment, which is a nationally governed program,
Mhm.
maybe that could be an issue. But I don't think most states, and it seem to be the red and blue states, seem to have some laws in place to protect victims of domestic violence. So I'd be shocked if that was really likely to be targeted by anybody to weaken or get rid of. In all honesty,
Okay.
but you never know what you never know. But
Wisdom from Tom Jones. All right, let's turn our attention now to our final area. A manager suspects an employee is impaired. What qualifies as reasonable suspicion, and what are our next steps? My hunch is, as soon as you say reasonable suspicion, that sounds like a legal thing.
Mhm.
Tom, why don't you kick us off on this one?
I mean, states have a variety of different ways you can drug test. Reasonable suspicion is probably the one that's more complicated and implies more responsibility on the part of the company to determine whether this person is actually impaired. I mean, pre-employment is, you can do that for everybody. Post-injury is a very small subset of people.
Mhm.
Random tends to be safety-sensitive workplaces, and so relatively few people involved in those groups.
Mhm.
Reasonable suspicion, however, is really what's different about this person. I watch this coworker come in every single day. He or she does the same thing with their tools, with their clothing, with their processes at work. All of a sudden, I'm starting to see changes. More frequently absent, more frequently late, and so I begin to think, maybe that's there's a good thing that we've developed here at AIM. We have a checklist, kind of a mental checklist that says, what do you go through? Was this person walking differently? Are they talking differently? Are they, some people speak slowly. Some people speak fast naturally. So what you're looking at is it different than what it used to be? If it is different, maybe that's the time to have a conversation with someone and say, what prompts those changes going on with that person? Maybe, and the other thing about reasonable suspicion you would want to think about is, so if I'm the supervisor and I'm observing you, Pete, and you seem to be different, I wouldn't just rely on myself, because I could have it in for you. I could be the manager who's out to get you. So I think I want Terry to go by independently from me and observe what's going on. If she comes back with the same results, then say, okay, there seems to be something different here. Let's pursue that in a conversation. And in some ways, it's part of the conversation, very awkward conversation, maybe up front, but still has to be had. And say, here's what we've observed, Pete.
Yeah.
And
okay. Terry, weigh in. How do you make this conversation less awkward?
I think it's about setting up expectations for the employees. So Tom mentioned reasonable suspicion, pre-employment drug testing. It's about having a policy. So you're
Mhm.
explaining to the employees, these are the expectations at work. It's a drug-free, alcohol-free workplace. And talking about when things might be addressed. So maybe a lot of employees don't read word for word everything in the policies that we hope they do, but if you have a policy to point to, then we can talk about that and say, again, kind of combining what Tom said, having that checklist available, so training your managers or your supervisors on this checklist. Talking again, there's a lot of different ways to look at it. It could be the actions, it could be their appearance, it could be a smell of alcohol or speech, or walking. It could be anything, so that you have this in front of you, and your employees realize when you come up to them and say, I'm not, I always just reiterate, I'm not sure that I hope you know about our drug free policy in this workplace, and talking about, we do drug testing in some instances. One of them is when we have a reasonable suspicion, so we have reason to believe you're impaired at the workplace, which could impact your safety to be here or the safety of others. So this is what we've observed. And as Tom said, this would be after you've made your observation, you've had another manager or supervisor also kind of second that, check off their items, and then sitting down and talking to them about it. Again, in a policy, the other reason it's helpful to have the policy is it's very clear the next step. The next step in the policy would be,
Right.
now you have to be brought to this local clinic to have a drug or alcohol testing done. We will bring you. Because it's funny, some people will say, well, I'll just tell them to go. Well, if you think they're impaired, do you think it's a good idea that they're driving?
Right.
So we want to bring them, and then you sit with them until they've had the test. And then it's nice in a policy when you talk about what could happen afterwards. Some policies say it might be an immediate termination if you're found to be impaired in the workplace and it's proven. Others say, you know what, we're going to give you a chance. We'll give you a chance to make a change. We'll give you a last chance agreement. If you want to go get help, we want to support you in that. So if you have the policy, it's a little clearer to the employee what can happen. It might not be quite as, chaotic of a situation as it could be if they didn't know that could be expected at the workplace.
That it's such an interesting perspective. I wonder if you have recommendations, because I keep thinking about, if you're impaired and somebody approaches you with this suspicion, it's possible you might be one of the belligerent respondents to this too.
Of course.
And so the policy is what dictates, hey, we have the agency and authority to request this test, and you agreed to that whether you read it or not.
Yeah.
On the backside of this, though, we've created policies that are employee forward for body odor. We'll buy products to help with that if we can. We'll change, work environment. We'll do that. Someone's experiencing domestic abuse, we'll go the extra mile to help make sure they feel safe and comfortable. What is your recommendation around a policy stance on helping employees get sober if that's what they need? Which side of that policy works best? The conservative, no strikes, like you're just done, or a little bit more progressive, hey, we're gonna help you figure this out?
I mean, one of the things that often comes up on the helpline is that people will say, I'm sure that employee is drunk, impaired. I say, you're going to test him? No need to. I say, well, that looks like a real risky statement, because that's going to come back on you if the employee pushes back. So you've got to give them at least an opportunity to try and clarify their status, because sometimes you get false positives. Most times companies are right, but not always. And so that's one thing you could do about it to help. The other is that the Americans with Disabilities Act offers people protection legally if you're in a program. So if you sign up for a last chance agreement, you're disabled within the eyes of the law. So if you have to spend the rest of your life going to AA meetings, so be it. That's a reasonable accommodation the employer has to try and make in the workplace. Some of these new state family and disability leave, family leave laws have the same sort of provision in there regarding rehab programs. So you're starting to see more and more protections emerge for people, and that helps a lot. I think you've got to have a policy in place to start the ball rolling. So, as Terry and I were talking yesterday, you don't necessarily the OSHA has a rule that says employers have a general duty to maintain a safe and healthy workplace. So if you don't have a drug testing policy, in a bind, you could fall back on that and say, well, look, I think your impairment may well cause injury to yourself or other
Mhm.
coworkers. Therefore, we're going to act based on that. Then going forward, I create a policy afterwards, but you know,
Yeah.
in that particular panic moment, you have something to fall back on.
Okay.
I think the policy, to your point, Pete, is and Tom, is it's the better way to go if you can, because it's an expectation and the employee knows what they're doing. And going back to what you said, Pete, which way do you go? Do you go the hard, everybody's terminated if they're positive, or do you go down the road of if they want help, they can get it? In my experience, when I've worked in different companies, the road of if you want help, you can get it seems to be a better conversation with somebody. I mean, even if they know that they may have a problem, they know that they're not necessarily going to lose their job over it. When they think they're going to
Mhm.
lose their job over it, they become more belligerent. They become more,
Mhm.
argumentative in your office because they think they're saving their job, which is understandable. So having that policy where you say, you know what, if this comes back and all of a sudden they start saying, well, I don't have a problem. Well, it came back positive. You have you have a choice. You can
Yeah.
take a termination, or we can work to help you and do a last
Mhm.
chance agreement with you. Talk about what you need to do in order to stay employed with us. And I'd say over 90% of the time, people take that last chance agreement. And I've seen people definitely get through it, go for the help, get what they need. And then in some instances, you have a positive that's related to a medical condition like Tom's referring to. So it's not always because something's wrong that they're doing. It could be something medical.
But as more states deal with this whole issue of medical marijuana,
Yeah.
it becomes more of a challenge because alcohol is relatively, you know, easy to determine its
Mhm.
impact, the impairment, smell it, and it goes away for relatively quickly. Marijuana is often just told stays in your body a long period of time. You maybe used marijuana on the weekend 3 weeks ago, it's still there. And so the company has to make a decision about what they're going to do.
Right. And
with
we're in
it.
a state where it's legal for
Mm-hmm.
recreational use, right?
Exactly.
Yeah.
We're seeing more and more companies, in fact, take that out of their drug testing protocol.
Marijuana.
In medical marijuana, yeah, the cannabis being removed from the drug testing protocol, so they'll be focused on amphetamine, the harder drugs, quote
Right.
unquote.
Right.
And
Interesting.
not that because they figure that exactly what you said. So many more people are using it. It's so much more available, and 30, 40 states have medical marijuana laws.
Right.
When we're
So-
talking a lot about expectations of employees, Tom and I both are, but
Yeah.
it's also important to make sure your managers are trained on the policy, on what to do, the right way to handle it, because a lot of times if they don't know how to handle it, if they don't know there's a reasonable suspicion checklist, if they don't know to bring it to HR, obviously things can happen. People can get hurt, and if somebody else hurts somebody different, there's still liability involved.
Right. Right.
Yep.
Well, what a timely answer to a question that actually came in from the comments. In addition to a handbook policy update, what about proactively training managers to understand how to handle this stuff?
Yeah, absolutely.
Part of the challenge with proactively training people is when they don't have context to understand what happens, it can
right.
go sort of one ear out in one ear out the other.
Right.
So,
Yeah.
ever vigilant.
Unfortunately, more and more people nowadays are starting to have that experience where they had someone work for them and they were impaired. So
Mhm.
they, and oftentimes someone in the room will say, "Oh yeah, we had this guy so and so. He or she was here, and they did this, that. We had to take the following steps." So it's getting more and more familiar for a lot of managers,
Yeah.
It is.
unfortunately, but it is.
And I think the training is important. So, as you said, Pete, reasonable suspicion training isn't just to train the HR people. It's to train your managers and supervisors. They're the ones interacting with everybody and making sure. I know when we do a lot of our reasonable suspicion training, we do commonly get the HR audience because they need to understand what to do if they want to put that policy in place. But it's even more important to get the managers trained too.
Sure,
It's
sure.
good for an HR person to have that knowledge and how to put it in a policy. But if the manager doesn't know how to take that and run with it, it can be difficult. And like we just said, it could cause liability issues.
Institutional awareness, word of the
Mm.
day.
Yes, there you go.
Oh,
Good one.
we've got some links in the notes that we're going to be putting in there. First of all, Tom's given us the Massachusetts Domestic Violence Leave Law. You'll be able to find that in the notes. And as always, AIM members can reach out to the HR helpline. You might get the famous Terry Cook or Tom Jones
That's right.
when you call this number, 800-470-6277, or email helpline@aimnet.org. Inquiries Monday through Friday from 8:30 a.m. to 5 p.m. Eastern time. Thank you, Tom and Terry, for this conversation today. I've learned so much.
Good.
Thanks, Pete.
Glad, Pete. Enjoyed it.
And
Excellent.
thank you all for downloading and listening to this show. Don't forget, if you have an interest in past conversations, you can find them, these webinars on our YouTube channel. You can also subscribe to our podcast anywhere your favorite podcasts are. Just search for Human Solutions and you'll find it. We've got season after season of these kinds of conversations, and we would love you to use them as a library to support your work as an HR professional. On behalf of Terry Cook and Tom Jones, I'm Pete Wright, and we'll see you next month right here on Human Solutions.